Thank you, Chairman. Mr. Petersen, do judges have an obligation of independence and neutrality?
Excuse me. Sorry about that. Yes, they do.
And it's extremely important that they honor that obligation of independence and neutrality, is it not?
Absolutely.
What are the concomitant obligations of an FEC commissioner?
An FEC commissioner, while they are appointed, the way the commission is constructed is that a member of, there may not be.
I know how it's constructed.
Yes.
What are the obligations of a commissioner? Are you obligated to follow the law?
Yes, absolutely.
Neutrally?
Yes.
Dispassionately?
Yes.
So you take an oath that is similar to the oath that you'll be asked to take as a judge when you're sworn in as an FEC commissioner?
Yes, absolutely.
What are employers allowed to do to force employees to contribute to or support political candidates under American law?
Under the Federal Election Campaign Act, employers, corporations can set up what are called separate segregated funds or connected PACs, and there are.
What are they allowed to do to force employees to contribute to candidates
or
support candidates?
There are protections against coercion that
So it's actually illegal for an employer to coerce an employee to support a particular political candidate, correct?
Correct.
All right, so let's take a look at some of the decisions that you participated in. Murray Energy is a very prominent Republican political force. It turns up in many, many different ways. Murray Energy Corporation came before the Federal Election Commission on the recommendation of the Office of General Counsel that they were telling employees that if you don't contribute, your job is at stake. The evidence included a memo from management saying, we have been insulted by every salaried employee who does not support our efforts, that if we do not win this election, the coal industry will be eliminated, and so will your job. If you want to remain in this industry, please respond to this request, which was a request to participate in political activity. And then further on, the same company mandated attendance at a rally, and the statement was made that letters have gone around with lists of employees who did not attend or donate to political events. Now, at the FEC, before you can begin an investigation, the commission has to vote to investigate. So it's not a judgment on the merits, it's just the opening of an investigation, correct?
Yes, that's correct, and it's a reason to believe standard that triggers an investigation.
You voted in both of those matters against even opening an investigation, is that correct?
That's correct.
And then we go on to the legendary Crossroads GPS, which is probably one of the most emblematic Republican dark money political operations that's out there, started by Karl Rove years ago. Crossroads GPS reported spending $15.4 million, which the FEC Office of General Counsel concluded expressly advocated for the election or defeat of a federal candidate, and suggested to the commission that the Crossroads GPS had failed to register as a political committee despite spending tens of millions of dollars to influence federal elections. I also believe that there were filings at the Federal Election Commission regarding expenditures by Crossroads that if you took them over to the Internal Revenue Service to look at similar filings protecting the 501c4 status, you'd find that the two things were both said under oath and both inconsistent with one another. So in that environment, on two matters, you were one of three Republican appointees to the Federal Election Commission who voted against even proceeding to investigation against Crossroads GPS, were you not?
Yes.
My time has expired, Mr. Chairman, but it's hard for me to believe that a man who has taken an oath of neutrality and dispassionate obligation to follow the law and then makes these rather extraordinary judgments that these matters should not even be investigated when big Republican political actors are involved, is going to be very capable of being neutral and dispassionate when he's asked to take an oath as a judge. And I would invite Mr. Petersen to answer as in any way he wishes further. My time has run out, but I don't want him to feel railroaded here. And if he has more that he'd like to say, I invite him to respond for the record in writing.
If you want to, you have that opportunity because Senator Whitehouse asked this question before the last second ran out, so you can have what time you need, and then I'll call on Senator Coons.
There are some of the matters that Senator Whitehouse referenced that I can't speak to because they're in litigation, and it would be inappropriate for me to comment on that further. But I'd be happy to try to provide some additional information that I think would provide some, I think, helpful context around what those decisions
You understand the
involved.
problem that I'm facing.
I
If, in
understand.
fact, every time a Republican entity comes in and you refuse even to investigate as a Republican appointee, and that decision is made not on the merits, but out of party loyalty or tribalism or whatever, that's obviously not a great predicate for somebody who wishes to be a U.S. district judge. You would agree with at least that proposition?
What I would say is that as a commissioner, from the time that I've been there for now over 9 years, I have, in every matter that I confront, I start with looking at the law, looking at the regulations, and looking at the relevant case law that is out there and is voluminous, and I recognize is unpopular amongst some and is controversial. But I'm obligated as a commissioner to follow those precedents that have been set forth by the Supreme Court, by the D.C. Circuit Court of Appeals, and other courts. And I believe that if you look at the totality of my record, you will find that I have found violations for corporations, and there have been times when I haven't. I don't think that you would be able to look and see that I have favored one side of the aisle or one side of the ideological spectrum. In fact, I'm quite certain that I haven't. And that is even as a commissioner who sits on a Republican seat, I take my responsibility very seriously and carefully. That I don't sit there as someone who has the thumb on the scale for respondents who are supposedly on my side. I have an obligation.
But if you were to, hypothetically, you would agree that that would not be a good attribute for a judge?
I would say I don't believe that that's what I have done. I would say that if someone enforced the law according to a partisan agenda, I would say that that would absolutely be inappropriate. I don't believe that that's what I've done. I don't believe that that's what my record shows.
Fair enough. I've taken too much time, and we can explore this
Senator
further in writings. Mr. Kacsmaryk, it would be wrong for us to base a vote for or against your confirmation on your religious beliefs, correct?
Senator, I think that arguably violates Article 6.
And it would probably be wrong in addition to technically violating Article 6.
Yes, Senator.
Yeah. It would also be wrong for you as a judge to impose on the parties appearing before you your own religious beliefs. Also correct?
That's correct. We have an establishment clause that creates that sanctuary for conscience, and that's a good thing.
And it is reasonable for senators to ask your assurance that you won't do that, correct?
Senators, I think it is reasonable to ask if I can abide by an oath that requires me to fairly and impartially apply the law as it is written, regardless of my religious beliefs. Yes, I think that is part of your advise and consent function.
And can you give me that assurance?
I will. Yes, I do.
Perfect. Chairman, thank you very much.
Senator Hirano.